My honor and pleasure to be a part of this Knowledge Group webinar today and to be with Mr. Flanagan as well. So why don't we, with no further ado, kick this off. I'm going to talk about some white-collar enforcement areas as well as some new enforcement priorities and policies. If we could go to the next slide, please. Thank you. The Justice Department has made certain funding requests, and from those requests you can see that they're focusing a lot now on immigration, which has been in the news, gang violence, which has been in the news, as well as cybersecurity issues. But that doesn't mean the Justice Department is going to walk away from white-collar criminal enforcement. Nothing could be further from the truth. And what I wanted to talk to you about today is to start with a couple of areas that federal prosecutors are consistently focusing on in the white-collar area. The first is money laundering, 18 U.S.C. Section 1957. Money laundering usually involves a situation where you have another crime or a derivative crime that you got proceeds from, and then someone comes in and commits maybe wire, mail, or bank fraud, and then that money is tainted because it is the proceeds of a fraud. Money laundering occurs the moment that person enters into another transaction with those tainted proceeds and tries to, in essence, launder that illegal gotten money. Another area that's a sharp focus for prosecutors is healthcare fraud and anti-kickback cases. 42 U.S.C. Section 1320. This is a very active area. They're very concerned about fraud crimes. There's a lot of money in healthcare. A lot of federally funded dollars go into healthcare. So they're very vigilant about policing and prosecuting situations where they find people who are engaged in fraud in the healthcare area. These cases generally stem from where a doctor or practitioner might refer a patient to another servicer or practitioner in exchange for a kickback payment. That payment for that underlying medical service involves government funding. That's illegal, and that will get you the attention of a federal prosecutor. Simply put, there's a bright line rule that a doctor cannot get a kickback for making a referral for a Medicare or Medicaid patient. Another sharp area of focus from prosecutors involves insider trading. As you well know, it's a type of securities fraud which essentially involves taking of material and non-public information about a company and using it to trade. Therefore, you have a leg up on the rest of the marketplace. People are very want to countenance this type of activity. This is something that they've been going after for years and continue to go after. There's been some recent controversy in this area, and it involves something that's referred to as expert networks. And some hedge funds have been recently accused of improperly reaching out to experts in a particular industry. And what has been going on is the hedge fund will pay these experts to provide information about what was going on at their job or in the industry in general. And then the fund makes trades based on that information. The sharing of general industry knowledge is permissible, but insider trading occurs when these experts steal information from their employers and provide it to hedge fund personnel in exchange for payment. And that would be in violation of not only their duty to employers, but violate insider trading laws as well. Securities fraud, another area involving fraud in the purchase and sale of securities, also involves various types of stock manipulation schemes that are regularly receiving attention from both prosecutors and regulators. And also you have situations now with the internet of what people call internet fraud cases. And one area that's getting some attention is what people call astroturfing. Astroturfing cases occurs when people create fake grassroots support for the business or product by engaging in advertising fraud on the internet. That is, by creating fake reviews for their business which prosecutors treat as an advertising fraud. If we can go to the next slide, please. What I wanted to take a moment and talk to you about, because I think it's important given our audience and given our subject matter, is factors that are considered by prosecutors when they're charging or considering charging a business organization. The U.S. Attorney has a manual that goes over how they make prosecutorial decisions, and in that manual they discuss factors that they consider when prosecuting corporations. The first factor that they consider is the nature and seriousness of the offense, including the risk of harm to the public and applicable policies and priorities, if any, governing the prosecution of corporations. 2, the pervasiveness of wrongdoing within the corporation. Is anyone condoning the wrongdoing, especially corporate management? The corporation's history of similar misconduct, including prior criminal, civil, and regulatory enforcement actions. 4, the corporation's willingness to cooperate in the investigation of its agents. That's often a very important factor in whether or not charges are ever brought against the corporation. The existence and effectiveness of the corporation's pre-existing compliance programs. I think you'd be hard-pressed today to find a major corporation in this country, I dare say you couldn't, that doesn't have a compliance program in place. It's not only important to have a compliance program in place, it's important that that compliance program is regularly tested and that you can show an outside prosecutor or regulator that there are ways in which you test the effectiveness of your own compliance program. It's not just a binder that's kept on the shelf of your compliance officer and never receives any further attention. So that's a very important aspect that the prosecutors will look at in deciding whether or not to charge your company. The corporation's timely and voluntary disclosure of wrongdoing. We're going to touch on this in a moment when we get into a different area, but that's really what prosecutors put an emphasis on, not only in making charging decisions, but also in extending mitigation credit at the end of a prosecution. You really are in a position where timely and voluntarily disclosure of wrongdoing can go a long way in helping you either avoid a prosecution or get you a lighter fine or sentence at the end of the investigation and subsequent prosecution. Next slide, please. 7, the corporation's remedial actions, including any efforts to implement an effective corporate compliance program or to improve an existing one, to replace responsible management, to discipline or terminate wrongdoers, to pay restitution, to cooperate with the relevant government agencies. So if some wrongdoing is uncovered in the company, you're going to be expected to take remedial actions, and that remedial action is going to have to take place really before the investigation or the prosecution is over with, so that you can either get an agreement with the government not to file an action against your company, or 2, to get the mitigation credit to ultimately reduce the corporate fine that the company has to pay. So if you have individuals that are involved, they want those individuals to be disciplined and or terminated depending on what the extent of the wrongdoing is. And this dovetails into the Yates memo, which I'll talk about a little bit at the end. Collateral consequences, including whether there's disproportionate harm to shareholders, pension holders, employees, or others not proving personally culpable, as well as impact on the public arising from the prosecution. So they're going to be concerned if there is a prosecution, are there innocent parties, whether they be shareholders, pension holders, or employees that would be harmed by a certain prosecution. So they want to see what the effects would be had on those different groups. The adequacy of remedies such as civil or regulatory enforcement actions. So there may be a civil enforcement action like an SEC action. So you've complied with that, you've paid a penalty, and that may be sufficient so that there doesn't need to be a separate criminal prosecution by a U.S. Attorney's Office. The adequacy of the prosecution of individuals responsible for the corporation's malfeasance. Like I said before, If there's individuals involved, they're going to want those individuals to have paid some level of a price as they move forward with the investigation and make ultimate charging decisions or recommend certain fines or settlements in their investigation. The goal of the Department of Justice's new enforcement pilot program involving FCPA matters is designed to promote greater accountability for individuals and companies that engage in corporate crime by motivating companies to voluntarily self-disclose and fully cooperate with the fraud section and remediate certain areas of their controls and compliance programs. The Department of Justice has set up some guidelines to what they're going to look for. First is going to be voluntary self-disclosure of criminality. 2, full cooperation. 3, remediation by the business organization for purposes of qualifying for mitigation credit. So what we've seen during this one-year pilot program is that if you voluntarily self-disclose the criminality, you have an opportunity to avoid prosecution. If you don't voluntarily self-disclose, you're not going to get a declination of prosecution, which is the ultimate goal here. 2, full cooperation. Full cooperation is important because it affects what level of mitigation credit you'll get. So that's something they look at. And in addition, once you self-disclose, you're going to have to do remediation efforts to fix the area within the company or your business organization that caused the problem to begin with. All right, if we could go to the next slide, please. Mitigation credit. Companies that voluntarily self-disclose as well as fully cooperate qualify for a full range of potential mitigation credit, including the maximum reward, as I just said a moment ago, which is the declination of prosecution. Significantly, companies that do not voluntarily disclose violations receive markedly less credit. If we go to the next slide. Extension of the pilot program. In December of this year, the Department of Justice indicated that they wanted to continue this program even though it was set to expire in April. At that event, Acting Assistant Attorney General Kenneth Blanco, at a speech at the ABA's National Institute on White-Collar Crime, stated that the Criminal Division remains committed to vigorously investigating and prosecuting international crime when it violates U.S. laws, and by remaining committed to international collaboration and our nation's shared struggle to safeguard our citizens, our markets and financial systems, and our networks. This indicates that this FCPA pilot program and increased focus is not going to end under this administration. If we could please go to the next slide. All right, the status of the Yates memo. So back in September of 2015, then Deputy Attorney General Sally Yates authored what's now become a relatively well-known and famous memo that's been named the Yates memo. And in that memo, Sally Yates outlined the fact that the Justice Department was no longer interested in just resolving corporate criminal investigations with having the corporation take a corporate crime, paying a fine, and moving on. They wanted the people within the company or the wrongdoers to be subject to prosecution. And if they were, that would have an effect on the company's ability to have a successful resolution of the case and may affect the ultimate fine they had to pay. So there was a priority put on the prosecution of individuals who were involved in corporate misconduct. People wondered when the new administration came in what the status of the Yates memo would be, because among lawyers, the Yates memo can be somewhat controversial because lawyers believe that there are times when the corporation is looking to quote-unquote scapegoat somebody so that they can get the advantage of cooperating with the government, while someone who may not really bear criminal liability or that much criminal liability is forced to pay in an effort to assist or help the corporation. Well, in a speech at the annual Conference of Ethics and Compliance Initiative, Our current Attorney General, Jeff Sessions, indicated that the administration remained committed to white-collar enforcement priorities. He praised compliance efforts. He also stated that the Department of Justice remains committed to not only enforcing all laws, but those that involve corporate misconduct, fraud, foreign corruption, other types of white-collar crime. He indicated the Department of Justice will continue to emphasize the importance of holding individuals accountable for corporate misconduct. It is not merely companies, but specific individuals who break the law. We will work closely with our law enforcement partners, both here and abroad, to bring these persons to justice. And that has been widely interpreted that the Yates memo under this current Justice Department is not going anywhere, that they're going to follow the outlines of the Yates memo as they move forward to prosecute white-collar crime. And as I said earlier, the FCPA pilot program is clearly staying in place. And I did not talk about this. I talked about this the first time before we lost audio, but I do want to touch base on something. If we could go back for a second to the FCPA pilot program regarding trends. The Department of Justice has resolved 18 of those cases over the last year, and in those cases, 7 companies who resolved their misconduct self-reported the misconduct. 5 of those 7 companies were allowed to receive the ultimate reward under the pilot program, which was a declination of prosecution. Further, no company that self-reported was required to engage a corporate compliance monitor, but all 7 of the self-disclosing companies were forced to return profits from the illegal conduct. It's important, I think, to see that as this program has rolled out, that there is a benefit to self-disclosing, and that not only do you get mitigation credit, but you stand the greatest chance of avoiding a prosecution if you self-disclose. If you don't self-disclose, you won't get as much mitigation credit, and you're often likely to get a monitor, and monitorships for companies, depending on the level of conduct that's trying to be controlled, can be extremely expensive. So that's something to keep in mind as you move forward.